state today. These are my co-counsels, Elizabeth Fletcher and Chelsea Chiagana. Today we are charging the defendant, Danny Dawson, with driving under the influence and then murder in the first degree. We have a few evidentiary matters to attend to, if that's all right.
Yes.
First of all, there's a picture of the victim that died in the drunk driving murder. Her name is Vanessa Sullivan. We'd like to offer it in evidence.
All right, any objection?
No objections, Your Honor. We've seen the picture.
It'll be received.
Further, there is the defendant in the case refused to take a breathalyzer test whenever taken to the station. It's already been stipulated by both sides, and all the objections have been waived, that the refusal to be offered into evidence.
I'll accept that representation. It'll be received.
May I approach the bench?
Yes, you may.
And if you would look on page 2, where it says refused, yes is circled.
Okay, any other matters?
Yes, Your Honor. We have a few more questions about how you would like your courtroom run. First of all, may we walk around the well during statements and examinations?
Yes, you may.
Further, do you want us to ask to approach the bench opposing counsel and the witness?
That will not be necessary. You do not need to request permission.
Also, we would like to invoke Rule 615 of the Midlands Rules of Evidence, the constructive sequestration of all witnesses in today's case, except for the defendant, and in our case, our party representative will be the police officer that arrived on the scene, Ryan Foster.
That motion is granted. All non-party witnesses or representatives are ordered excluded from the courtroom.
And finally, may we assume that all objections are constructively argued outside of the earshot of the jury?
That will be the procedure, yes.
Your Honor, with that, the state is ready for trial today.
Thank you. Are there any other preliminary matters by the defense?
Just a couple things, Your Honor. First, can we introduce ourselves?
You certainly may.
My name is Jordan Dixon, and today I, along with my co-counsel, Sarah Takamoto.
Good afternoon, Your Honor.
And Pablo Luca-Robles.
Good afternoon, Your Honor.
Represent Danny Dawson in today's case. The only issues we have, Your Honor, is we'd just like to tender to the bench a copy of the jury instructions and also the penal code for the bench to reference, and also the jury later on.
Very well.
And with that, Your Honor, the defense is ready.
Okay. All right. Mr. Prosecutor, do you wish to make an opening statement?
We do, Your Honor.
Okay, you may proceed.
May it please the court? The defendant was supposed to be the designated driver, but the defendant drove drunk. Because the defendant drove drunk, a young girl is dead. Vanessa Sullivan, who will never get to know the joy of another day, let alone another birthday, was killed by the defendant. That night, she invited him with her to celebrate her 21st birthday. All she'd asked in return is that the defendant be aware he might have to be the designated driver. The defendant, she agreed, but that night she drinks and she doesn't stop. The defendant was the first one to arrive at the bar, Chubby's, that night. She went in, she went straight to the bar, she had a drink. And then she had another drink, and another drink, and another drink still, until finally Vanessa and her friend Taylor come, and the defendant, she walked with them to a seat, sits down with these two girls that she's promised to get home safely, and she orders another drink. And that's not the end of it. And you're going to hear this. You're going to hear this from the server that night. She's going to tell you that after watching the defendant down drink after drink, the thought of her getting behind a wheel and driving was laughable. The defendant knew this, because the defendant asked the server for pills to help her concentrate. She didn't get those pills to help her concentrate. What she got instead was a shot of grain alcohol. And with that shot of grain alcohol, she hops behind the wheel of a car after drinking all day and speeds out of the parking lot and into the road. And you're going to hear that from the cab driver that night. The cab driver is going to tell you that after offering the defendant a ride time and time again, the defendant refused. The defendant thought that after sitting in this bar all day, drinking and requesting a concentration pill, that she was fine to drive. They get in the car with her, and they drive that night in the pouring rain, with the defendant swerving all over the road, the defendant's windshield on max, struggling, squinting to see the road ahead of her. That night, she swerves her way to Canyon Road. She swerves off the road, and then she swerves back on, and then she crashes Vanessa's car into a pole and smashes Vanessa herself into a tree. You're going to hear from the first responding officer that night of how, after hearing the defendant say that she needed another drink, that after performing 4 field sobriety tests, all of which the defendant failed, the defendant still refused to take a breathalyzer test. Now, we as the prosecution, we have the burden of proof. We have to prove to you beyond a reasonable doubt of the defendant's driving under the intoxication and murder. We're going to do that. Speeding in the dark. She didn't slow down because it was dark. She sped on. The defendant sped even though there was torrential downpour, even though she'd been drinking in a bar all day. She gambled with the life of Vanessa Sullivan and Taylor Hobson. And she lost the life of Vanessa Sullivan. The defendant gets to walk away. All Vanessa's parents got was the phone call that every parent fears. They got to hear that the daughter that they'd loved for 21 years, that they'd raised, taken to the dentist when she got her first 2 teeth, taken to the park and cared for, was dead. Instead of celebrating her life on her birthday, for the rest of their lives, they have to mourn her death. My co-counsel, Elizabeth Fletcher, is going to ask you for a verdict at the end of this trial. Find the defendant guilty.
Thank you very much. I would be the defense, I'd like to make an opening statement at this time.
Yes, Your Honor.
You may.
May I proceed?
Yes, you may.
Today's case is about a tragedy, not a crime. One night of fun took a drastic turn and a life was lost. My client, Danny Dawson, was driving that night on September 24th, 2010. She lost her friend, Vanessa Sullivan. Danny Dawson made a mistake. We are not going to contest that, but a mistake is not murder. The prosecution must prove to you beyond a reasonable doubt that Miss Dawson might as well have known getting behind the wheel of the car would directly result in her friend's death. Today, they will not be able to carry that heavy burden. On September 24th, Miss Dawson arrived at Chucky's bar early after a rough interview. The evidence will show you that Miss Dawson wasn't worried about driving that